Hello everyone, thank you for joining us for our weekly video. In today's video, I'm going to answer a question that we get sometimes from people that panic after a foreclosure sale and they realize that the sale amount at the auction was not sufficient to cover the total debt amount on the mortgage. So what do I mean by that? They're essentially asking, will I be personally responsible for the difference in what was received at the auction and what I actually owed? So let's say, for instance, I owe a total of $600,000 on my mortgage, and at the time of the foreclosure sale, because I couldn't do anything about it for whatever reason, and the foreclosure went forward, at the time of the foreclosure sale, the highest bid, which would be the winning bid, was for $500,000. That means there's a $100,000 difference there potentially that the lender is still owed that amount. So the question is, are they truly still owed that amount? And if so, can they come after me now that they've already sold my property? So that's the question that I'll be answering today. And my answer is, it depends. That's the favorite answer. If you've ever talked to attorneys, they will tell you it depends, because it always depends on a lot of factors in that specific situation. So what do I mean by that? In most states, the mortgage loans are recourse loans, meaning that yes, the mortgage lender can come back and ask for more if they didn't get enough when they sold the collateral, which is the actual property. In 12 states, however, the mortgage loans could be non-recourse loans, meaning that once they've taken the collateral, they can take nothing more. And I'll explain the logic here in a bit. I'm in the state of Texas, and in Texas, as with everything else, we have both. We have judicial foreclosures and non-judicial foreclosures. We have sometimes the mortgage loans being recourse loans, and sometimes they're non-recourse loans. In Texas, the mortgage loans that are tied to your homestead, if they're home equity loans, they are non-recourse loans. Nobody wants to jeopardize your shelter, let's say, the only roof over your head. So that would usually be a non-recourse loan here in Texas. I don't know about other states. In Texas, if it's not a home equity mortgage, then it could be considered as a recourse loan, depending on what your loan documents would say. And I would say that even if it's recourse here in Texas, the lenders don't have the habit of coming after people after the foreclosure sale. I would think that it rarely occurs, because most of the time they get close to the amount because they've done a good job in valuating the property up front, appraising the appraising the property up front, trying to figure out potentially what could it sell for in future, A, and B, they're also probably good, I hope, at moving fast if they believe that they will never get paid again. So they'll move fast and do the sale before the amount of the debt is overwhelming. And of course, as you know, they've already gotten paid most likely by the time the foreclosure sale happens, because they've already collected interest for many, many years, as well as the principal amount. So most of the time, even if they did a credit bid, they've already been paid more than enough. So that's probably why they don't come after people even when they have a recourse type of mortgage. So let me go into the definitions a little bit. And when we're talking about that amount of the difference, we're calling it a deficiency. So if I owed them $600,000 and they only got $500,000, there's a potential deficiency of $100,000. And I'm saying potential because it could be a little bit more. Let's say there were additional fees for the trustee at the sale that had not been factored in yet. So maybe I owe them $100,000 in looking at the overall deal. And then we have to look at the law and say, well, what state am I in? That's the state's law that would apply. And if that state says there is no recourse at all with that type of mortgage, then they couldn't ever come after me anyway. If it is a recourse type of state where the lender is allowed to come after me, then they could come after me in court by suing me for that deficiency, and they'll then get a deficiency judgment. They will then have to enforce the judgment by trying to collect on it. So there are many, many steps involved that you have layers of protection in which to try to work something out, even if this did happen, and you try to negotiate a discounted payoff. So they would have to sue typically, and they would have to then try to enforce by either getting a writ from the court to have a constable go out, see whether I have non-exempt assets that they can seize and sell, or they can try to garnish wages depending on what state we're in, and things like that. So they could try to enforce that judgment, of course. They could also file it into the county's records and wait patiently for years, so that if I happen to get some money in future, they could then try to collect at that point. So that's how the deficiency judgments would work. It's against the owner personally, or if it's a company, it will be against the company that owns that property, beyond the collateral. So that's essentially what the deficiency judgment is. The collateral is there for the lender to feel secure in the loan. So let's say they gave me that loan for, at the beginning, $500,000. They should have done an appraisal on the property to make sure that that property was actually worth around $500,000, so that in future, if I did default, they would at least be able to get that money back, the 500,000. But typically they want the property to appraise at the amount of the loan or a little bit higher. So that's their due diligence that they have to do, and they also have to do the due diligence of moving forward with a foreclosure sale before I accumulate too much of a debt. And the reason why the debt could keep accruing more and more is because the interest keeps accruing more and more as long as I keep falling behind on my payments. So sometimes these lenders are very careless and incompetent in that they will not do a foreclosure sale for 1 year, 2 years, 3 years. So by the time that they do the sale, the amount of the debt is quite significant, and the market might have changed where the value of the property is not as high as it was before. So then there might be that discrepancy in the value that they had appraised it at before and the value now. And so when they go to the auction, they're getting the highest bid, which does not cover how much I owe them total. So that's what the deficiency would be. And then the things that you have to keep in mind is that if you have the home equity loan, as I said, in Texas, you're fine because that's a non-recourse automatically. And then the other mortgages that are recourse loans, they don't come after people for, I haven't seen it much, unless there's a significant amount involved, of course. And typically they will go after companies first. Let's say you're an investor, that you're using your company to do the investments. They might be prone to come after you more than an individual, because the individuals could always find a lot more defenses than a company could. So that's the logic, I think, behind that, the rationale. Those states that try to protect their citizens more, those 12 states include Texas, Arizona, North Dakota, North Carolina, Connecticut, Utah, and a handful of other ones. So if you're in California and if you're in those states, then you don't really have to worry as much. And then the other thing I wanted to mention is that if, for instance, you have it as a commercial property or investment property and you took out, let's say, a business type of loan, or a loan from a hard money lender who are private lenders that give people these types of loans, higher risk loans, let's say, they still have to follow the laws in the state you're in. Because you can borrow money from anywhere. You could borrow money from a lender that's in Canada. You could borrow money from a lender that's in New York, but you live in Texas. And so the property that you're buying might be in Texas. In that case, the law of Texas will still apply. So that's what people sort of get confused on. Like, okay, well, the property is in Texas. Yes, the law of Texas will still apply because this is where the property is. And that particular law trumps the law of wherever the lender is or wherever you are even. So you both could be in different places and the property is in another state. Let's say the property is in Utah and you are in New York and your lender is over there in Canada. the laws of Utah will still be applied when you go to court. The venue of the case, if they do sue you, that is determined by whether you selected that in the documents or not. The actual venue of the lawsuit when they do sue depends on whether there was a choice of venue in the loan documents, in the agreements, or not. So if there is a choice of venue in your loan documents, they're going to try very hard to sue you in that place. So most of these lenders that do the other types of loans, they try to squeeze in a clause inside the agreement that would say they could sue you where they like, the place where they think is most favorable to them, or where it's more convenient for them or for their lawyers to get to. So they would pick a place, and you probably don't notice that when you're excited to get the loan and you're signing the documents, and that's typically in there. If it's not in there, then they have to sue either where that property is located. That's really it. Most times, if they don't sue you where the property is located, then they sue where you are located as the defendant. So those are the options that they have when the lawsuit happens. If you have a lawyer defending you at the time that they sue you, the lawyer could file a motion for a change of venue and argue against wherever they sued you if it's not convenient for you to get there, if it's going to be very oppressive for them to sue you somewhere else, meaning that you have to spend a lot of money just to get to court and things like that. So your lawyer could still try to change the venue regardless, just so you know. And we've been successful at doing that in the past. So those are the things to take into consideration. And I wanted to also mention that at times when these lenders come after people for the recourse type loans, they try to get more money than they should be able to get. So what do I mean by that? Let's say in that example that I gave at the beginning, where they sold the property for $500,000 as the highest bid, and I owed them $600,000, so they will try to come after me for $100,000. But if my lawyer in court can prove to the judge that the fair market value of that property was actually closer to $590, then they must give me an offset, a credit of $590, not the actual $500 that they accepted at the auction. So my lawyer would be able to successfully argue that it was valued according to the market, if we can prove that the property was valued at $590, and so they undersold it. So they undersold it. That means that I get the credit of the $590 regardless of how they did the auction, and I will then only owe them $10,000. So that's what it's like when you have a good lawyer on your side and your lawyer is doing his or her best to defend you, to protect you, to mitigate your losses, to manage any damages, things like that. So that's what I wanted to share with you on this video. The key takeaways is that you should always try to find out, am I in a recourse or non-recourse state, number one. As I said, in Texas, you are in both. We have recourse mortgage loans and non-recourse mortgage loans. I will do another video to go into Texas specifically so that we can really understand which ones tend to be recourse and which ones are non-recourse. And then you also want to know whether you signed a personal guarantee if it's that type of a loan. Some people take out SBA loans, small business administration loans, to be able to complete their deals for commercial property. If you do that, typically you will sign a personal guarantee. The personal guarantee is not conclusive in saying that you will absolutely be responsible if there is a deficiency, if there's a shortage. So the personal guarantee, in my opinion, is still sometimes open to argument and open to attack. And this is why I say that. In Texas law, the case law, meaning that the cases that have gone through court and been decided, sometimes the personal guarantee is scrutinized. You look at it thoroughly to see whether its intention was to be a blanket guarantee, meaning that I sign to guarantee that no matter what, if you take the collateral and the collateral does not satisfy what I owe or what the company owes, then I personally will guarantee to pay you that deficiency. So there are some guarantees that are blanket like that. Some are only triggered or are only covering the instance in which there is bad faith action on the part of the borrower. So let's say the company borrowed the money or you borrowed the money and now you're a personal guarantor. Then you could say, I guarantee that I will be personally held liable for any deficiencies if the company acts in this way. So the ways that they're talking about is if there's a bankruptcy, let's say, and somehow it wasn't disclosed to them or they weren't able to get their claim in bankruptcy, or if there was fraud involved in my application, or if I failed to disclose things, dishonesty, fraud, and sometimes bankruptcy. So those are the things sometimes that the personal guarantee would be for. It's not a blanket, oh, I will be liable regardless, so you have to have a lawyer that can look at all your documents seriously and really go line by line and try to find defenses for you. That's if you're already in it. If you're not yet in it, make sure you understand what you're signing before you sign. So in my opinion, it's always worth it to pay that little money up front to do a consultation with an attorney. It might look like a lot, but imagine the thousands of dollars that it could save you in the future if you end up not signing a bad document. So these are my thoughts on that. And the third takeaway from this video would be that even, let's say this had all happened before you watch this video, and you now have a lender coming after you for a deficiency judgment. They're trying to get a deficiency judgment, and they're sending you these threatening letters and showing you that your statement shows that you might owe them $400,000 because they sold the property for $1 million, and you owe them $1.4 million on the commercial property, let's say. And now you're freaking out. So you don't have to freak out. Just get a lawyer in the state where the property is located, because remember, the property's location, the law would usually decide what happens. So make sure you talk to a lawyer where the property is located, not necessarily where you're located, not where the lender is located, but where the property is located. Regardless of where the lawsuit is filed, the laws of the site of the property would be used in the courtroom. So make sure that you talk to that lawyer and ask them, does this look right, and does the state allow us to use the fair market value to offset the debt? And what can I do to avoid the lawsuit at all to begin with? So your lawyer might actually be able to prevent that lawsuit by arguing upfront that they used the wrong number. Instead of $1 million that they used, if the fair market value was closer to 1.3, then your lawyer would argue with them upfront before you get to court. And hopefully that resolves it. So anyway, this is my video for you for today, and I think I try to make it as clear as possible. I hope that this helps you out to know the triggers that you have to look out for. Is, am I in a recourse or non-recourse place? Am I in both, like in Texas? And if so, is this particular loan recourse or non-recourse? Did I sign a document called a personal guarantee, or am I about to sign one? And if so, I need a professional set of eyes on that document and on all my loan documents to be able to tell me what I'm doing here. And if it's already happened and somebody's threatening to sue you for the deficiency judgment or deficiency that occurred, then you do need a lawyer to help you figure out how to mitigate that, to make sure that you don't owe them as much as they claim you owe them, because trust me, they will try to get the maximum amount of judgment against you. So I hope this video has been helpful to you. If so, make sure to subscribe, and if you feel like seeing the other videos in future, you can hit that bell button for the notifications to be sent to you when we upload new videos. We'll try to do them weekly, and if you have questions that you want us to answer, remember, do not put questions on YouTube regarding specific situations, because we don't check YouTube regularly enough to do that. We can only do a consultation with you if you contact us directly. We are not allowed to come out here and give advice. So this video is for educational purposes, as we always say. Thank you again for watching, and I hope you guys have a wonderful weekend. Hope this has been insightful, and I'll talk to you next time.